Welcome everyone to this Exploring Legal Futures webinar. The topic, as you know, is on the distinction between solicitors and barristers, and I'm very excited to introduce three graduates of the university for our discussion this afternoon. Those are Trudy Yates, who is at Hogan Lovells and a graduate of Peterhouse in 2018. We have Michaela Glass, also at Hogan Lovells, who graduated from Jesus in 2020, and then also James Mitchell, who is at Maitland Chambers, who graduated from Downing College in 2013. Just briefly before we go to each of our panelists for a discussion on the different topics, I'll just give a brief overview of the structure of the webinar. So we will, apart from after the panel introduction, we will go to an overview of the different career paths represented by becoming a solicitor or a barrister in England and Wales. We'll look at some of the specifics around that choice, and we'll ask the panelists their experience of making that choice, and we'll move on to what makes a successful solicitor, what makes a successful barrister in the current legal industry. There will be an opportunity for questions. There's a Q&A function, so if you have questions that occur to you as the webinar progresses, please do enter those into the Q&A, and we have some pre-submitted questions as well, and so there will be a chance at the end for a discussion of those. So without any further ado, I'd like to hand over to the panelists to introduce themselves, and we can kick off the webinar this evening. So thank you very much. And so perhaps, if I call on Trudy perhaps first to introduce herself, and we'll take it from there.
Sure, thanks. So I am a second seater at Hogan Lovells. I'm coming to the end of my second seat. So what that means is that your training contract is broken down into 6-month rotations. So my first seat was in intellectual property patent litigation. My second seat's in pensions, and I'm going to move into DCM, which is a finance seat. So only a year left, halfway through.
Thank you, Trudy. Perhaps Michaela, would you like to come in now?
Hi, so I'm Michaela. I'm also a Hogan Lovells trainee. I'm in my first seat, so I've just finished my first 6 months. I've been sitting in project finance, so I'm moving next to arbitration. And I studied a master's in corporate law when I was at Cambridge, and before that I did an undergraduate degree and worked at the bar in Australia.
And James, if
I'm sorry, I can't turn my video on, but I'm sure that's going to be no loss to the participants. I'm a barrister at Maitland Chambers, and I have practiced as a barrister we're in my 5th year of practice now. I studied at the law tripos at Cambridge a long time ago now, in between 2013 and 2016. And I then did a master's at the other place for a year before coming straight to the bar.
Thank you, James. So we've got this opportunity to discuss, among ourselves, the various potential and pitfalls of becoming a solicitor and a barrister. I wonder if we can start by just asking or giving a basic overview of what a solicitor does, what a barrister does, and when you start to think about making this choice in your legal career. So James, you already have the floor. Do you want to come in with a little bit on the barrister side, and then perhaps one of Trudy and Michaela can talk about that from a solicitor's point of view?
Yes. So barristers are those lawyers who are focused mainly or predominantly on litigation. We are lawyers who generally predominantly have the rights of audience to address the court, and so our focus, or the work that we do, tends to be dispute resolution kinds of issues And that ranges, of course, from all the way from criminal matters, which is something I don't touch, through to commercial litigation and commercial arbitration.
Perhaps without unfairly picking on one of Trudy or Michaela, but Michaela, would you like to come in just to give a brief overview of the solicitor's work?
Sure. So a solicitor does the other parts of legal work. So the way it was explained to me when I was choosing was basically solicitors generally do the front end and then barristers do the back end. So if you think of like all the deals that are being negotiated when you want to take out a loan, when you want to build an airport, when you want to buy another company, like mergers and acquisitions, kind of like what you see in suits, they're solicitors. And there are also solicitors who work on disputes. So they'll sort of instruct barristers and work in sort of the more preliminary stages of dispute resolution. But we kind of pick up the other things. So we don't go to court. We're more face-to-face with the client, sitting here sort of deciding what the rate should be on a loan and how you should negotiate, sort of who will have what rights in a deal.
Trudy, do you have anything to add to that? Or
no, not really. Sorry. I guess I would say that from my perspective, so I'm in a sort of regulatory advisory seat at the moment. I think the main difference between what I do as a solicitor and what a barrister does is that we have quite limited contact with barristers. We only go to a barrister if there's a particular point of view that we need or that we can't, a question that we can't answer ourselves. So I'd say that the solicitor does the more practical stuff, more day-to-day stuff. And I would say the barrister tends to do the more intellectual black letter law kind of stuff.
When would you say, you start making this choice in terms of a career path? At what point does it become material, to your future career that you so in terms of extracurricular activities, summer work that you might do, when is it that fork or divergence starts to make itself felt?
Well, perhaps jumping in, for me, personally, it started making itself felt when I didn't get a vaccine in my second year. So I thought, well, let's not faff around with this again. I'll go to the bar. I mean, a little bit more seriously, I think I had always been attracted to some of the work that the bar does, particularly the advocacy, or being argumentative, and the academic or black letter nature of the role that a barrister undertakes, as Trudy says. Often I'll get wheeled out when there's a problem that someone can't otherwise answer, or there's a particularly difficult legal issue to look at. And that appealed to me when I was studying law, and I thought, well, I may as well try and pursue that side of the profession.
How possible is it to keep your options open, or do you kind of have to take, the plunge on one side or the other at some point? What's your, is it easy to move between the two, or what point does it become difficult to move between the two such that you have to make that choice?
I mean, if I'm answering that question, I think it depends whether you get a training contract in your second year or not. That, I guess, getting a training contract in your second year or your third year if you're a non-law student like I was, it's kind of like the golden point, because that's when, you're secure and that all of your legal qualifications are paid for, and that, you're going to get into the legal field as soon as you possibly can. So if you get a training contract, you have to sign on the dotted line. You can't really keep your options open after that. I think if you're willing to take a gap year, if you're willing to wait a little bit longer, if you're willing to do a direct training contract application rather than doing the back scheme, possibly that's a bit risky depending on your perspective, but it is possible to keep your options open a little bit longer, because I think in terms of the bar, sometimes you apply for pupillage after you've done the bar course, but generally there's differences around funding. So it really depends how you're funding things, how much support you're going to need as to how long you can keep your options open. But I'm not an expert in funding for the bar, so maybe that's one for James.
Well, perhaps just jumping in there. So the way that, and probably moving slightly further down the list of questions I've got in front of me. The way that training to become a barrister works, assuming you've done a law degree. If you haven't done a law degree, there's a second stage, but assuming you've done a law degree, you have to do a 1-year course, which I think is now called the bar training course. It's changed its name every 3 or 4 years, which you can get funding for either by applying to the Inns of Court, which are basically like colleges for barristers. And they have scholarship programs, so you can apply for a scholarship and you can get funding that way. Or the ideal situation is that you apply for pupillage before you do your bar course. And most chambers, including my own, will allow you to draw down, I think for 2025, my chambers will allow you to draw down £30,000 to pay for your bar course fee and for living on as well. But if you don't have those options, then funding is more difficult, obviously.
I'm not sure. Obviously, it's not to do with qualification, but I would add I requalified. So for what it's worth, quite a lot of people have career swaps. Most people from another career entirely, but I requalified from being a judge's associate in Australia, which would mean that I was at a barrister by British standards, and then came to the UK and went back and did what are the solicitors qualifying exams now, and then a training contract. So it's never too late. Obviously, that meant like financially I had to take a hit and come back and requalify, but I could still use my law degree and still come to be a solicitor. So that option is there. If you do decide that one is not for you, you don't have to leave the law entirely. It's not a lifetime commitment.
Sort of glancing ahead, but it might be useful then just to quickly and kind of clearly set out the staging posts, as it were, along the way. If we start with, becoming a solicitor and then comparing that to the staging posts in terms of becoming a barrister. So I don't know if one of you wouldn't mind just sort of quite clearly setting that out so we have in mind the same sort of framework.
So for a solicitor, if you've done a law degree, then that's sort of ignore the next bit. If you haven't done a law degree, you need to do the GDL, which is a conversion degree.
You don't need to do that anymore.
Oh, you don't? We still require you to do that. A lot of firms will still require you to do that.
Yeah.
Okay, so depending on the firm, I still had to do it. So I, as of this cohort, I still had to go back and do a conversion degree despite having 2 undergrad law degrees. So you have to do that depending on the firm. Then you do the solicitors qualifying exams, which everyone has to do. And they're new. They came in this year, sort of the first year they're mandatory for everybody. And they're sort of a general exam akin to what they have in sort of America. We now have here, which is basically like it's an exam on everything you would study in an undergrad law degree, and then a few other things that you would have studied previously in what was a different course that doesn't exist anymore, that sort of prepares you for practice. So it's got things like criminal law, commercial law, all in one exam. And that basically, there's 2 stages of that. So they're 6 months apart generally. You'll sit both stages of that. Then you'll go to a law firm and do qualifying work experience, which generally looks like a training contract. And you have to do 2 years of that. So that's work sort of under supervision. And then after you've got your 2 years of work under supervision and you sat those exams and passed those exams, then you apply to be admitted as a lawyer, as a solicitor, I think, if I've got that right. Trudy, have I got that right? Okay.
Thank you, Michaela. That's enormously helpful. I don't know if, James, you're able to add to that.
Like, it's illuminating that the process has changed from when I was looking at it. For barristers, if you, as far as I'm aware, and I did not specifically check this, as I didn't know there was a change, certainly in the solicitor profession, but as far as I'm aware, if you are a non-law student, you do have to do a conversion course, the GDL, for a year. Once you've done that, or if you have a law undergraduate degree, you have to then do something called the bar training course that I mentioned earlier. I think it is now, it wasn't when I did it, but I think it is now in two stages over the course of a single year, where you have a sort of academic based half, which is basically learning some civil procedure and criminal procedure and various other black letter topics that you can somewhat more self-study. And then there's a practical part, which is some of the skills, advocacy skills and drafting skills you need as a barrister that is taught later on. And then you have to do a 1-year pupillage, which is essentially a year in inner chambers, learning how to be a barrister. And after that, you can practice on your own. Well, indeed, in some chambers, you can practice after the first 6 months of doing pupillage, but that depends.
Thank you, James. Maybe we should sort of move on to some of the more holistic questions, I suppose. Having gone through the granular detail of the qualification process. I mean, one question that we have here, which just about your experience, is, you know, what made you personally choose one rather than the other? Is it to do with personality or just the kind of work patterns that you like? What was the motivation for the decision from your points of view? Trudy, would you like to answer, sort of respond to that?
Sure. So essentially, I was in a position where I'd essentially got onto a bar mentoring program, and I also had a training contract offer. And essentially, the offer was, well, the choice was one of financial means, essentially, and there's considerably more financial support that is sort of given to you as a right when you have a training contract. Whereas I think there's slightly more hoops to get through in terms of bar funding. And, you know, I'm first generation student, all that kind of stuff. So it was quite simply economic. There was another element to it, I guess, which is about, would I prefer, you know, getting up in a courtroom and presenting arguments and the front-facing stuff, or do I want to do more of the background, you know, more of the caseload? I want to spend longer working on cases, I guess, rather than just doing sort of the end bits. But yeah, I think the economics of it was the main factor for me, which is not the most inspiring answer, but there we go.
Oh, but it's very important, and it's the kind of practical insight that's very helpful. Michaela, do you have anything to add to that, or to your own experience?
Yeah, so I chose wrong the first time. So I went back. I got a do-over. So I initially thought I wanted to be a barrister because I loved moot court at uni. I did the Viz moot, I did the Oxford IP moot, I went all over the world mooting through undergrad and absolutely loved it. Mooted for Australia a few times and thought it was the best thing ever. And then went to work as a judge's associate and realised I don't like black letter law at all. And I don't like having to be responsible for things on my own. I'm a team player. I like being involved with the team. I like having someone to discuss things with. So I actually was going to leave the law and go into business. And then the judge I was working for said, "You don't hate the law, you just hate this job. Why don't you go and become a solicitor?" And so I went and did my master's in corporate law, which was focused on like deals and sort of M&A and sort of debt financing and the sort of things that we do as solicitors. Loved it, applied here, and have like absolutely loved every single day since I made the switch. So nothing against the bar. It's great. I am like a golden retriever. I should not be left in a room by myself with my thoughts. And so I love working in a team, and I love having other people to ask questions and to negotiate with, and that much more like casual interpersonal kind of relationship that I just didn't have when I was sort of responsible for giving a black letter law answer by myself.
I think the answer I'd give to this question was probably when I was deciding to become a barrister is probably different to the answer I'd give now as to why I am still a barrister and probably will always be a barrister as long as I'm healthy enough to practice. So I think at the time, as I mentioned earlier, when I was a student thinking about what I wanted to do, it was the argumentative nature of being an advocate, and the academic rigor that I felt was more suited. A barrister's role was more suited to, because although there are aspects of solicitors' work where that would be black letter law will be relevant, and part of your day-to-day job, doing deals doesn't necessarily, getting deals over the line won't necessarily require those skills. I think now the reason I'm still a barrister is for those reasons, but I mainly like being self-employed and being accountable to myself. Now, being accountable to myself is a bit of a double-edged sword, in the sense that if I'm feeling under the weather, or if I've got too much work on, it's my own fault, and I've just got to get it done. I've got to deal with it. But equally, I don't ever feel like I'm working or being billed out at an hourly rate far more than I ever see in my pocket, and working for someone else in conditions which I haven't put myself under. So I think those are the reasons why I would now say I want to stay a barrister. But I think the answers I would have given as a student would have been slightly different.
It sounds like the team player, not that barristers aren't necessarily team players, but that sort of team environment versus the more solitary role is quite a significant one, just from a day-to-day point of view. James, you mentioned being self-employed. Does that bring with it extra risks, or from a sort of financial point of view? How would you frame the difference between the actual structural kind of self-employment versus a salaried role, perhaps with a firm?
So I think being self-employed is less certain financially. I have no idea how much money I will receive in my bank account this month, because I do not know when my solicitors will get the money off their clients or pay me, essentially. I would say two things there about, and also I don't have an employee pension paying into topping up my for my future, so I have to manage that all myself. I don't think, certainly at the commercial bar, that should be a concern so much, because we are fortunate enough to be able to command fees that allow you to ride, even out the peaks and troughs of self-employed practice. So yeah, it is a factor, and for some people it will be a determinative factor, along with other, if you're being offered a training contract worth X many £1,000s a year, and then a potential full-time job on a fantastic salary, it will be difficult to turn down. I totally get that. I would urge those who are interested in advocacy, court work, and black letter law to turn down the glitzy offers that big city law firms can sell you. But it is a different way of being employed.
And not to dwell on barristers more than solicitors, but just a follow-on question: how long does it take, as somebody entering the profession, to establish yourself and to sort of build up the work? Then is that an issue, or does the work come quite freely early on, or what kind of factors are relevant there, would you say?
I think there's two factors. I think if you're in a good set of chambers, the work will be coming through chambers, and it will be coming, and there'll be work going to senior members of chambers who have a great reputation, who need junior people to assist on and to help with. And the second point is, as soon as you start practicing, the best way to advertise and market yourself is to do a good job and to be someone good to work with, so that those solicitors come back to you. I'm 5 years in, so I've had a decent run, and I have solicitors who come and use me on the basis that we've worked with each other before.
if I could ask a more general question again, just about the skills. We've spoken about the difference in the work and sort of the day-to-day, but if you, what skills do you think are the sort of essential skills for a solicitor? If we start either Michaela or Trudy, I don't know if you have a view on that.
I think the skills kind of depend on what seat you're in. So, for instance, in my previous seat, patent litigation, there are kind of similar skills like formulating an argument, I guess, when you get to a higher level and you're doing that. But I think there are some things that are always there. So being able to research really efficiently, being able to work in a team is really important, being able to delegate and also have things delegated to you. I think it's mostly soft skills, I would say, that transfer between seats. Whereas I think if you're already interested in black letter law and you want to be a solicitor, there is an opportunity to do that in things like pensions. But generally, it's more practical, being more commercially minded, being really conscious of what your client actually wants, and spotting issues essentially. Like the barrister, I guess, would get the issues and has to solve them, and your job is to kind of find issues that haven't been found yet, I guess.
Yeah, I would agree with Trudy. The most important things tend to be these soft skills, and I was thinking about this before this thinking about like the difference between a barrister and a solicitor, and I do believe from my experience from both sides, communication skills are actually probably one of the most important both ways. They just kind of reflect themselves differently. So for example, some of the most important things in my role here are being able to communicate what I'm doing with my team members, with my supervisor, and with my client, and then being able to put down legal arguments in really simple commercial language. So being able to explain why we're doing a particular thing in a deal in a simple email that makes sense to people who aren't lawyers, which is quite a different way of communicating to a barrister making submissions in court. And so one of the key skills, I would say, is this communication both orally and in writing, and being able to explain legal arguments to people who are not lawyers.
James, is there a core skill set that you would say you couldn't do without as a barrister?
No, I mean it's difficult because in a sense many of the skills that Trudy and Michaela just mentioned are applicable to barristers as well. I mean, we do have to, as much as some barristers aren't as good as this they should be, we do have to have a commercial sense of what the client is wanting, because otherwise you come unstuck, or you advise something that just is never going to fly commercially. I think that I think the way to answer this is the two core skills we look for in applicants are your reasoning and analysis, because you have to be able to take large amounts of information and analyze that. And I suspect that is very much a skill you need as a solicitor. And persuasion, which is a facet of communication that Michaela mentioned. So I think those are probably the two key skills.
One sort of lurking in the background, but a common question that comes up is sort of what is meant by this commercial awareness sort of concept that gets bandied around. And I think that's sort of been in the background of what's just been said, but I don't know if you could sort of give your view on what commercial awareness means in the context of, somebody who's applying for or thinking about becoming a solicitor or barrister. I don't know if I could call on perhaps Trudy or Michaela to give their view on that, but it might not be much different from what's already been said. But
I think it sort of was what James was alluding to, is basically commercial awareness is this idea that when we're giving legal advice, you're not giving that in a vacuum. You have to understand what the client actually wants to do. So one way that it presented itself when I was sort of looking at applying for jobs was in interviews. I would go and they would give you a scenario and they say, like, how would you advise the client? And you have to sort of show that you understand that what is like the most legally perfect answer might not be what that client needs. So the example that I had was that like the most legally perfect answer was that they had a right to stay in this property for this lease, but actually like the high street is dying and everyone's moving online. And so you had to understand that the client just wants to get out. And so commercial awareness is that ability to say, I know this is technically, you've got A, B, and C, but C is actually best for what your business need is. And then being able to go to the client straight with C rather than saying you've got A, B, and C and them going, cool, what do I do with that? It's going back to them with C in words that make sense to them and saying, because of the way your business works, you should do C, so that they can just get on with it and they can run with that advice.
So that's extremely helpful. I mean, obviously, being a solicitor, being a barrister, in contact with all areas of the economy, all areas of life. I mean, how quickly do you specialize in these roles?
So as a solicitor, at most city firms, at ours at least, you do this training contract which has seats, as Trudy mentioned. So for us, we have 4, some of them have 6, but they tend to be sort of 4 to 6 rotations across 2 years. And then at the end of that, you'll apply to one of those seats, which will be a specialist team. And that's where you will train. So there are options to train more generally and then specialize down. So I know people who have sort of trained in like a banking seat and then gone to a specific subset of banking, like asset finance or project finance. But generally you have those 2 years of trying things out and then you apply to a specific team.
James, is that choice, do you sort of quite quickly become specialized in an area, or do you have opportunities to kind of shop around?
Yeah, so there's obviously 2 areas. I think there are 2 phases of specialization. The first phase is, where do you do your pupillage and where do you practice from stage. So I have specialized because I am not a family barrister. I am not a criminal law barrister. I'm a commercial barrister, commercial property barrister as well. And then there's specialisms within what your chambers do. I am not specialised yet within what Maitland do. I do a bit of all sorts. I do some straight up commercial work. I do some civil fraud. I do some insolvency. I do some property. So I think there's probably more scope at the bar to have a wider set of areas of practice potentially. But you can also end up specialising, and a large part of it, and it can be driven by you and what you want to really do. But it can also be down to a little bit of luck and what cases you get instructed on and repeat instructions arising out of
that. So if you were in the position of of many of our attendees at this webinar, and you're thinking, I'd like my aim is to go into a legal career. I'm thinking about becoming a solicitor, possibly a barrister. Perhaps not sure, but perhaps have a fairly good idea. What are the things that you would advise our attendees to be doing while they're on their degree in order to best prepare themselves for the various different sort of phases that we've spoken about earlier? I don't know if Trudy, do you want to? What would you say are the kind of activities in addition to the study, which is already quite onerous, that you would recommend people should be thinking about doing?
It's not really like a activity, but I guess make sure that you're engaging with the College Law Society and the University Law Society. So again, I mentioned a couple of mentoring sessions and schemes. They're all generally advertised by your college or university law society. And going on insight days, I know a couple of the intercourts run some, definitely all the law firms do, and back schemes. That's where you can ask those questions. You can sort of test the waters to see, what's it like in a law firm, what's it like in chambers or in a court, those kind of things. I guess in terms of extracurricular things, I think trying mooting, I think might be beneficial. It seems like everyone that applies to the bar has done mooting at some point, but if you're toying with the idea, if you don't know which to do, that's probably the best exposure you'll get to actually what it would be like. There's other things like debating, and the Cambridge Union, is very attractive, I guess, to people that want to pursue legal careers. It's definitely something that I did, but also just being involved in societies and, looking at positions that might develop legal skills, of being a secretary or a treasurer or anything like that is going to be beneficial. But I don't think there's any strict extracurriculars that you must do. Anything that shows that you're commercially engaged or that you're taking on responsibility, those are all kind of things that people will look for in interviews.
Taylor, is there anything that you'd like to add to that, or does that capture what you would suggest?
I would agree with that. The only other thing I would add is like, you don't panic if your extracurriculars aren't all academic, because none of mine were. I did moot court, but I was just like hugely involved in sport. I was on a sports scholarship. All I wanted to do was play sport. And that was fine because in all my interviews, they just asked me about my experience coaching sport and being part of sports societies and organizing like buses to races and being responsible for those sorts of things. So don't panic if you're about to apply for VAC schemes or whatever and you don't have heaps of inside days. I had none. I had no VAC scheme. I had no inside days. All I had done was had an understanding of why I wanted to do the job. I knew why I wanted to apply to that firm, and I was able to speak to my other experiences and why those were relevant. So I think that's really important, and also take the opportunity to do things that interest you more broadly. So I did sort of some student consulting and volunteered in the library and at the Holocaust Center and these sorts of things that I liked, and they are all relevant because you do gain experience. So, research experience and the ability to sort of archive and lead groups and talk, and these sort of things are all helpful, and it doesn't matter if they're not all college law societies. I didn't know my college had a college law society, so that wasn't a thing I did.
I couldn't agree more with what Michaela's just said, actually. It's obviously hard for me sitting on the other side, having got through the process and got there. But there are some very easy things you can do to assist your paper application. Having a good degree, meeting the minimum requirements or better of your degree, that will obviously help. For the bar, doing some mooting because you're at a university that offers you plenty of mooting opportunities seems like a sensible thing to do, but don't stress about it. And you don't need to win moot competitions to come to the bar or anything like that. I think the main thing that we look for, I think the main thing that's important is that we have a workplace and a team of varied and different people who have varied and different interests, and you should pursue your own interests because you will have something interesting to say and interesting to bring to chambers and whoever solicitors firms or whoever you work for. So I really do endorse what Michaela just said there.
I think it might be a good time to move the discussion on from sort of set piece kind of questions to responding to some of the questions that have come in and have been pre-submitted as well. So I can see one question that has been asked that bears upon this. And this attendee asks, may I ask how important a first class and mooting experiences in first year? Do chambers take into account the fact that it may be harder to get a first at Cambridge? And then they thank you for fielding the question. What do you think about shooting for the first and also trying to sustain these other commitments at the same time?
So I didn't get first class in my first year of law tripods. Obviously, it's down to I find this question difficult because I do not want to put anyone off who doesn't get a first class degree from applying to the bar, because that is not that is not a requirement. It's obviously helpful if you get one, because that will give you slightly more points on whatever assessment is made. But it's not the be all and end all. Mooting experience in the first year, if you don't have mooting on your CV, you can still apply and come to chambers. It just seems like a sensible. What we're looking for is evidence of you being able to persuade, and that's quite an easy thing for you to go and get that. But there's lots of other things you can do instead. My chambers, I believe, mark their paper applications university blind. So I think that's the answer to the final bit of the question.
And there's another question which builds very nicely on this, and it's open to all three of you, of course. But the question is, and feel free to either answer or not answer as you like. But what A levels did you all do, and what were your grades at university? But I suppose this is obviously very selected samples, so it's not necessarily demonstrative. But I think it might be nice, just for that background, if you're willing to come in with any of that information.
I'll go first. So I did IB. So I did high levels in history, psychology, and maths. And I did my extended essay in history. And then I did an undergraduate degree in history with an honours thesis focusing on Chinese history. And then an LLB. I wrote my honours thesis at Oxford on exchange. And then I did a master's in corporate law at Cambridge, and I did have firsts in all of them. But obviously, an arts degree is quite different to a law degree, and so I was also older. So,
okay, I'm going to sandwich myself in between these because these look like really sparkling CVs that you're getting. But I did biology, chemistry, English literature, history, and APQ, and got like A stars in those. And then my degree was history, and I got a first class, although I will preface that by saying that was a COVID year. So my exams were online, it was open book. So I think there were slightly inflated first class degrees, and I already had my training contract at that point. And in my first year, I think I got a first, but only just. And to be honest, I don't think anyone has ever cared or expressed a preference for a solicitor having a first. I think it's, if you meet the minimum requirements and you perform well in an interview, that's great. I think the A-level requirements are sort of like 3 A stars to C's, I think. And I've never heard that there's some kind of preference you having perfect A-levels. Like, a lot of people have imperfect A-levels. So I wouldn't get too caught up in that. Your A-levels are important to get to university, and then it's your degree that matters. And as long as it's a 2-1, in some respects, if it's a 2-2, as long as you can explain that, that's fine. But generally 2-1, and that's fine.
I should add so the way that the tripos sort of is assessed now has changed also in the last several years. So that now the degree outcome is based upon the combination of the final 2 years results, weighted 50% each year. So the kind of classification of the first year is separate and does not contribute to what is now the overall degree outcome, which is taken from the marks in the second and third year. So while the marks that you get in first year are important and will contribute to various applications that you're making at that stage, they quite quickly get overtaken by your subsequent degree outcome and things like this. So particularly in terms of the first year, it is an opportunity to really get stuck into the subject and not to worry too much about the actual classification of those marks, because, like I said, they get superseded by the overall degree classification at the end. But of course, they matter at the time, but then they, as with everything, like the A levels, they're overtaken by the most recent thing. So don't worry too much. At each stage, there's always another opportunity to do well that comes after. There are several questions that have come in on the practical side of just working as a solicitor or a barrister. So I thought maybe if I pitch some of those, I think a very nice one is, I have to find it quickly. What is the difference in the working hours between a solicitor and a barrister? How long is a piece of rope, I suppose?
Yeah, I was just going to say it varies massively based on where you are in a transaction, also what seat you're in. So in IP patent litigation, it was we were in court, we were in trial, and a lot of my working hours were quite long, particularly because I was waiting on barristers to send me things, and they're not the most punctual of people. So, there is more flexibility depending on where you are in a matter. Litigation seats, you get more idea of what's coming up, whereas transactional seats, things can come up during the course of your day, so it's a bit hard to plan your life. I jumped in because I'm currently studying pensions, which is a very nice seat, and there's very long time frames and everything. So I'll be leaving at 6 tonight, and 6:30 I think is the latest I've ever done. So it does depend on your practice area and where you are with your workload. But I can't speak towards the working hours of a barrister. I can only say that they tend to work just as hard as we do, or just as long as we do. But yeah.
Is that right, James?
Yes. Well, the thing about working hours is I choose my working hours depending on how much work I've got to do. So I think, in fairness, I probably work shorter. If I'm really busy, I will be trying to work at 7 a.m. and finish by 7 p.m. because I hate working in the evenings. But I also may choose to allow some work to bleed into the weekend if I've got some stuff to do. And it just really depends. When I was in trial, I had a 6-week trial at the end of last year. I worked pretty much every day, full days, but not into the night at all for most of that period. At the start of this year, I was very quiet, and I sat up with my feet on the sofa watching daytime TV, contemplating whether I was going to have a practice. So it does really depend.
Thank you. There is a question, and this may be difficult to answer specifically, but I think it's helpful for people who are listening in, which is just about sort of the financial side of it and remuneration. Is what in the current market, I suppose, what would you expect as a start, in your training contract, or then starting as a solicitor or an advocate, and how fast is the career progression in that respect in either one of those sort of paths?
So as a solicitor, it's quite easy to tell you what the market's looking like, because a lot of the firms are really transparent. So Hogan Lovells is an Anglo-American firm. We tend to be at the same level as Magic Circle firms, and they're all at the same level of about £50,000, maybe I think 60 is the highest I've seen in your first year, and then about 55 in your second year. And then after that, it's going to jump to about 120,000. In my listening to other people, the associate pay grades your jumps after that are a little bit smaller and tend to cap out about 200,000 before you move on to senior associate, etc. But yeah, generally you're looking about 50 to 60 in your training contract per year, and then 120 afterwards. But I would keep in mind that a lot of your fees have already been paid for if you have a training contract. So you're not paying for your GDL, or you're not paying for your your SQE, I guess now, but that's something to keep in mind.
There is also a bonus, not as a trainee, but as an associate. And I think one thing that I would say was quite key, not key, but something I took in mind when deciding to come to a firm and leave being a sole practitioner, was you get other things like I get paid leave, I get gym membership, I get food provided, I get a heavily subsidized canteen, these sorts of perks, cycle to work scheme, all these sorts of things that I do take into account when I consider the value of my sort of what I'm paid. So whilst the trainee salaries are online, they're about 50,000. I think the value in kind is more like 60, 65 when you include those sorts of things. So that stuff is all generally public information. You can find it for each firm, like Legal Cheek and these sorts of pages tell you things like that. But that was quite important for me to take into consideration.
The bar is a little bit more opaque and also a little bit more personal, and I'm going to demur what my income has been over the last few years, if I may. But what I will say is what is public available information, and that is our pupillage award. So the 1-year trained award is £70,000, and you can draw down £30,000 of that for paying for fees. For the first 6 months, that is treated as tax-free because it is study and not income for work. So there's a slight tax lift benefit there. And we say publicly that what we would expect, there's a cash flow assistance scheme to assist you in your first years of practice while you wait for fees to come in. And what we would expect you to earn in your first year would compare favourably to that is earned by a city solicitor. And on the basis of figures that I think Trudy gave, I would agree that statement is correct. And there is some relatively swift progression beyond that as your hourly rates increase. I see the benefit of that straight away.
Thank you, James. I'm conscious that we're coming up towards the end of the time, and there are many excellent questions, but I think it's probably going to be impossible to answer all of them.
Sorry, Peter, Can I just add on that last point?
Yes, of course.
That's from the perspective of a commercial barrister. There are other areas of the bar that are to great shame to the legal system are not remunerated as well as that.
Thank you, James. Yeah, but it's very important to this wide spectrum. So what I wanted just perhaps to finish by asking a very general question, which is, do you enjoy your job? What do you love about it? Or is there anything also that you don't like about it? But I thought I would just finish by asking each of you that question. Perhaps if Michaela, I can see you're perhaps ready to jump in.
I do love my job, I absolutely do. And I think I'm really grateful. Not that I've not always loved the law, but I know that, life as a sole practitioner wasn't for me. And I've absolutely loved this every day since I stepped back into a firm. I like working in a team. I like coming in and talking to other people about what they're doing. I like the ability to be involved on lots of different things in different capacities. And I like things like I go to lunch with my friends and I go to yoga on a Tuesday at lunchtime. And I like the rest that comes with working in this sort of big company. That really works well for me. It suits my personality. I absolutely love my job.
Rudy, do you, from the perspective of a trainee, what's your, what's your experience?
No, I love my job too. Basically for all the same reasons Michaela has said. What I would say is that obviously as a trainee, you're going through different practice areas. I think some seats are better than others. And in my current seat, there is a lot of black letter law. Too much for me. It's not the one. But there's good and bad parts of everything really. But
Thank you, Trudy. And James, maybe if I could ask, same question.
Absolutely love my job. Although there are certain days I'm sure I would tell you if I was asked the question that it's doing my headache. I couldn't see myself doing anything else. I think I like the responsibility and pressure that comes with it. Sometimes I am making calls in collaboration with a team, but I'm making calls on, I think you've got a 60, I think you're going to win this case. I think you've got a very good chance of winning this case, or I think we should drop this point entirely because it's hopeless. And sometimes those calls were on you, and it's can be stressful, but at the end of the day, I enjoy the responsibility and pressure that comes with having to make those decisions.
Thank you very much. So we've reached 5 to the hour, which was scheduled for our sort of end time. I just want to thank all our panelists for being with us today and providing their sort of insights and answering our questions. It's been such a pleasure to listen to you all discuss, this question about being a solicitor, being a barrister, and I'm sure that the attendees, people who've attended the webinar, have learned a lot from listening to your experiences. So thank you very much. And I think with that, we'll probably conclude the session.